Welcome to episode number 4 of Upstate and Litigate. I'm Derek Spada.
And I'm John DeGasperis. We are personal injury lawyers in the Hudson Valley. We're partners at the law firm of Basch Keegan. We hope you like the show. If you like it and want more educational material and information about all things personal injury law, feel free to subscribe to our page. Today we're going to talk about medical malpractice. You ready to go?
I'm as ready as I'm going to be.
All right. Well, it can be a dense topic, so today we're just going to introduce everyone to the most common types of medical malpractice cases, and then we'll discuss a little bit about the things that you and I as attorneys deal with in that first call or consultation.
Yeah, I'd say that they're the most complex types of personal injury cases.
Yeah, so we'll do many other shows about the many other topics that arise, but today we're just going to welcome people to the topic. All right, Derek. So first of all, I can't believe we're on episode 4. I've been getting a lot of positive feedback about our show.
I know, me too. People actually watch this. I'm shocked.
And they're learning. I think they're all very intrigued by what they see and hear from us. Although I think so far everybody's favorite was the story about the blue foundation at the office.
Yeah.
That was a hit. Well, I'm going to talk about my biggest settlement ever, which was $3.9 million for one of the saddest cases I've ever handled. There was a medical malpractice case. My client went to a local hospital up in the Capital District for a routine thyroidectomy, totally elective procedure. Took the bus by herself that morning to the hospital. Surgery was uncomplicated. The doctor successfully removes the thyroid. The hospital was very busy that day. They could not get her to a bed on the admitting floor. And so they left her in the post-anesthesia care PACU unit for like 5 hours, which is a very long PACU stay. It's an uncomfortable environment. It's very busy. There's no privacy. The bed is like a OR bed. It's not like a comfortable admitting bed. And she had complained of like tightness in her throat. They finally, after 5 hours, get her a room. And they call a technician to move this woman from the basement level of the hospital, which is where the operating department was, to the 5th floor. I'll never forget deposing the technician and just how scared she looked, even just telling the story. And the technician wheels our client down the hallway to the elevator. Elevator door opens. She pulls the bed onto the elevator. The door closes. And as the elevator starts to go up, our client sits up, writhing on the bed, grabbing at her chest or her neck, I'm sorry. So the elevator finally gets to the 5th floor. This technician wheels the client down the hall, screaming for help. Everybody runs to her. They call like a code blue on the floor. And then all the respiratory therapy comes. A physician comes. The physician was ultimately the negligent party. And he says, transfer her down to the ICU. Now, she's grabbing at her neck. She's bleeding at her neck. No one would concede blood until, I think it was like the 18th deposition. Remember, I took all those things.
Oh, yeah.
The nurse, and she was like a supervisory nurse, had been doing this for a long time, and she wasn't going to lie for the hospital, said she saw blood coming. So the proper thing to do would have been to stabilize the patient in the hallway at the floor, control this situation, but instead they send her down to the elevator, down from the 5th floor to the 4th floor to the 3rd floor, get her off of the elevator, wheel her down the hallway, into the ICU. All this time, she's like gasping for air. They get her into the ICU. They transfer her out of the bed. They have to call another code level. An anesthesiologist comes and intubates her. But by then, minutes had gone by, and she suffered an anoxic brain injury. And so we all worked together. We filed this big case against the hospital. It was a lot of work. It was 18 depositions, I think. This woman had really awful losses. We went to trial, settled in like the 2nd or 3rd day of trial for, I think, like $3.85 million, which wasn't enough, which was not enough for this woman whose life essentially ended. I mean, she didn't die, but She suffered awful. She was bedridden the rest of her life. And but we fought for her, and she wanted to accept the settlement. She wanted to move on. She wanted to secure the money for her family. But that was arguably one of the most powerful cases that I've touched so far, I think, and in terms of my experience and feeling like I was doing good, and I feel like we made the hospital safer, and we, I thought that the one doctor who decided to move her really screwed up. And I'm from my perspective, I thought that I hope this doctor knows, don't ever do that again. Like, when someone can't breathe, just figure the problem out right then and there. And that's just a medical malpractice case that I'll never forget. All right, so today we're talking about medical malpractice, and I think that we should sort of set the stage by telling our viewers the most common types of medical malpractice cases that we see in our practice or that get litigated in the courtrooms. So let's list them out. We'll put them on the screen so that everybody can learn.
Sure. So there's a fairly long list, but the main types are birth defects and birth injuries.
Then there are surgical errors. Of course, those involve errors or mistakes that occurred during surgery.
Foreign objects left behind during surgery. When the doctor forgets something, you don't want that.
There are anesthesia errors. Anesthesia is a very complicated area of medicine.
Misdiagnosis or failed to diagnose. For example, put this rash cream on that cancer. It doesn't work.
That definitely doesn't work. Failure to diagnose, that happens in many different settings, clinical settings, radiology studies. So that those cases really run the gambit. And then finally, we have prescription errors. Those usually occur when the drug is used incorrectly or the patient has an adverse reaction to a prescription drug. Those are the most common themes. Of course, every case is different, and there are various subsets in each of those categories. But those are the things that I think most frequently come across our desk. Any case type that you prefer to handle?
Not so much a case type, but I prefer when what happened is more clear cut, so it's one-on-one.
Yeah, totally.
Sometimes a person has a long course of being passed around from doctor to doctor, and it's just a gigantic mess. And then every doctor points to the other doctor and says he did it,
or she
did it. So then it just becomes a mess, and the records. I find the records are almost never really 100% accurate because the doctors are the ones, or their staff are the ones who make the records, so they control what goes in the records.
Yeah.
And no one ever types, "Oops, I messed up" in those records.
It happens, but it doesn't
Very
happen.
rarely.
It happens rarely, but you will find occasionally a good doctor, an honest doctor who just puts in the record, I made a mistake, or we as a team made a mistake, or they just didn't acknowledge, even if they don't say we made a mistake, they acknowledge that something went wrong and they put it in the record. So I always find that those are, as you're describing, the better cases because it's right there. All right, so I thought, why don't we start by sort of setting the stage. You and I, we field a lot of calls at the office with people who think that they may have been the victim of medical malpractice. And so I think it'd be a good idea to sort of welcome everybody to the common issues and adversities that we confront when we're contemplating taking on a case or evaluating the merit of a case. Why don't we first start by defining medical malpractice? So why don't we both give it a whirl? Tell me your definition, or maybe the legal definition of medical malpractice here in New York.
Well, from our perspective, we have to prove that there was what's called a deviation from a good and accepted medical practice or standard. And it's kind of like a loosely defined definition because there's not necessarily a book that explains what the standard is for every procedure out there.
There can be books sometimes, you're right, but not often.
There are books, but there's no Bible or whatever to go to rely on for all of these standards, which you'd think there would be because we have to prove that there was a violation of one of these standards. But the standards mean mainly what do doctors normally do in this situation and what's accepted in the medical profession.
Right.
And if what a doctor either did or didn't do is beyond what's accepted in the medical profession, then that's considered malpractice.
Right. And we establish the standard of care often by using another doctor, right? As you're saying, it's hard to establish the standard of care through the literature because usually there's no set standard of facts. And so the doctors are reacting to what they're dealing with. But what we do is we call another doctor with the same level of knowledge and expertise to tell us whether the treating provider or physician deviated from what a reasonably prudent doctor would have done under the same circumstances, or alternatively, what a reasonably prudent doctor would not have done if confronting those same circumstances. And that's actually, I think, a good area to start. One of the reasons why we are selective, highly selective, about accepting medical malpractice cases in our office is because we have to find a doctor, a different doctor, who will say that the treating doctor deviated from the standard of care or committed medical negligence. That is an expensive endeavor to find and hire a doctor to say that. It's a time-consuming endeavor. And so that is reason number one why medical malpractice cases are, one, difficult, and two, expensive.
Yeah, I'd say we get at least 25 phone calls or contacts about a possible malpractice case for every one that we take. And it could be even more than 25 to 1 out of 30 to 1, or it's hard to really even estimate. But I have to sift through, I'm sure you do too, a lot of phone calls and emails until you find one that even sounds like a case.
Yeah.
And then there's times that it sounds like a case, and you talk to an expert doctor who said, "Oh, that happens all the time." And they say, "Well, that's not malpractice."
Right. And I think too, to what you're saying, a lot of our phone calls involve patients who had a poor customer service experience. And poor customer service in the medical setting does not equate to medical negligence. It's purely bad customer service. So if a doctor has poor bedside manner, or if the medical practice or facility, screwed up with scheduling, those types of things don't usually amount to medical malpractice. What we are looking for is something where a medical physician or provider, like a nurse, a therapist, made a mistake that caused the harm. Because I think that's another major issue, is that many of the people who call our office, one, did not suffer any appreciable harm as a result of the doctor's negligence, or two, that individual was already doomed. And while I don't mean to sound cold about that, if we have to prove that the negligence changed the outcome, right? And I think that that's also a very difficult thing to do.
Yeah, I'd say about half the calls that I receive, if not even more, I think there was malpractice, but nothing really came of it.
Right, I agree.
So then, to have a case, you have to have an injury or some kind of damage or loss, and then that's what gives it value. Right. So if the doctor messed up every step of the way, but you still got a good result, then you've got malpractice, but not a malpractice case.
Correct. Right. I agree with you. Right. You have to prove, one, that there was negligence, two, that the negligence was a substantial factor in causing a harm, and then you have to prove a harm. And if you can't prove a harm, then even though the doctor may have deviated from the standard of care, there are no appreciable damages. And, I do think as trial lawyers, especially community-based trial lawyers, right? Most of our cases are within the Hudson Valley or just beyond. We have a certain duty and responsibility to the community and to the medical field to ensure that when mistakes occur, we bring attention to them and we help to try to improve the quality of care here in the community. But we also have to be selective about the battles that we choose. We can't take on every cause. So I think that we are often looking at the integrity and the merit of the case, and as you're describing, sort of like the simplicity of the issue. And also we're generally looking for relatively serious damages, not because we're greedy, but because it has to be worth the fight, right?
Yeah, these cases can well, they seem to always cost $10,000 at least, and they could cost upwards of $20,000 and sometimes more to pursue a malpractice case. And so if you have a case that's worth $20,000 and you spend $20,000 to pursue it, then even if you win, you've just wasted your time.
Right. And also, I think if you only have a $20,000 injury, it is a reflection of the injury quality, meaning that thankfully you weren't hurt worse. But when you have someone who suffers an anoxic brain injury, like the one case that we have or had, or someone who dies, or you have a child that is born with a lifelong permanent injury, those cases, not only are they financially more valuable, but they are more important to the world and to society and to the medical industry. So we take on those fights. So it's not always just a question of how much money will this case return. It just happens to be that the value of the case is a reflection of the suffering or the damages sustained by the individual. But that definitely goes into our sort of analysis and calculation about which battles to choose. Do you ever think about the doctor's reputation?
Yeah. I mean, that's part of it. But, well, I would say in the past, I thought more about that. And
what do you mean by that? So that's changing your analysis?
It is to some extent. And so I think in the past, I'm sure still, but in the past especially, doctors put their names on their practices. And now, if you look around, search doctors near me, whatever, you can find doctors' names, but you can't find those doctors' names in those practices, meaning there aren't really any solo practitioners anymore. There's been this shift toward corporate medicine, and so there's a corporate name on hospitals and medical practices. And so the doctor's reputation still matters, but their name's not on the practice, so people are calling a practice, they're not calling a doctor anymore. So you have to sift through the corporate layers until you can even see a doctor. And most people, when they go to a practice, like for the first time, they don't really even know what doctor they're going to see. They go into like an orthopedic practice or a neurological practice or whatever it happens to be, and they've talked to whoever answers the phone. They get an appointment. They go there, they meet with some doctor they never heard of. It's rare that they call a practice and ask for a certain doctor.
It's really interesting you say that, because I do consider the doctor's reputation when I'm evaluating a medical malpractice case, because I don't care to drag some doctor through the litigation process if it's a questionable case or, a case that lacks merit or lacks value. But it's a very low consideration for me. In other words, if I think I have a meritorious case, even if value is not extraordinary, I don't hesitate to bring it. But I do think that you're right that the corporate influence over medicine at all levels is something to be considered. And you know this. Well, what the average person doesn't know is that when they go to the emergency room anymore, even at a local hospital, the doctor that they see in that emergency room is likely not employed by the hospital. Would you agree?
Yeah, they typically are not direct employees of a hospital.
They're contracted with.
And oftentimes you don't see a doctor at the hospital.
Well, this is also true. And even your nurse practitioners, right? Like when the people you interact with in the emergency room are rarely employees of the hospital. This is cost shifting. This is liability shifting. But the consumer, the patient, is none the wiser. Somebody in a white jacket walks in the room. They think it's a doctor affiliated with the local hospital. And then come to find out when they get the bill later, the bill is for the doctor's name individually, because that doctor is really just part of a third-party contractor entity and that third-party contractor just fills hospitals with doctors. Now, that is a very critical distinction with the statute of limitations. Right? So if you go to a lawyer and you're like, oh, well, I got bad treatment at the hospital, and then we start digging and come to find out the doctor who treated you isn't a part of the hospital, we may not know who to go sue, right? Other than the doctor individually, but that doctor has an employer that may have more insurance. And these are all things that I think, like when they passed that law shortening the statute of limitations to 2.5 years, those things weren't factors then. Now they are, right? And again, the consumer, the patient is at a disadvantage. All right, so you get a phone call at the office. You're sitting at your desk, and the receptionist tells you, Derek, I have a medical malpractice call on the line. We do typically try to speak directly to the individual if the receptionist has vetted the case and it seems like it has merit. But what are some of the factors and considerations that you're using when deciding whether to bring a client in for a full consultation on what may be a medical malpractice case?
Well, first I try to get the story, or at least the main points of it from the client, and I ask them what they think the doctor did wrong exactly. And the clients, of course, don't always have all the details for you, but they can at least give you a rough outline. And every case is different, so I can't give you like a blanket answer. But I want at least one issue that I can hang on where a doctor did something wrong. So if a person calls me and says the doctor did these 7 things wrong, that's probably not a case.
Yeah, I don't like those. Those are no good.
So if there's one like sentinel thing that went wrong, then that sounds better. If there's 7 things that went wrong, you have to prove 7 things went wrong, and it just turns into like a mess typically.
It's always the worst when you're talking to somebody and they give you their lead topic, like where they think the doctor went awry, and then you say something to the effect of, well, that's probably not a case, and then they say, okay, but let me tell you about this other thing that they did wrong, and it's like, no,
that's
man,
not a
you
case
didn't
either.
get me on the first one.
Yeah.
We're definitely not doing your alternative theories here.
Yeah.
But yeah, no, I agree. So you're looking for a sentinel issue.
And then the damages or the injuries or what went wrong there and what the effect was. And if I feel like there's a major issue, something that went wrong that I can grasp onto, and that there's injuries or damages or financial losses that are, I'll say, like adequate enough, like I don't necessarily need $1 million case. I just want a case that's worth pursuing. And then I'll take a look at it. And from there, the next step is like get the medical records. If the person has them, that's great. If not, we can request them. And I'll also talk to an expert, there's a few doctors who I talk to on a fairly regular basis about these possible cases, and I'll just give them a phone call and try to bounce it off of them to see if it's something worth spending any time on or not. And usually they'll give me a straight answer whether I should spend time getting the records and working on the case or just passing on it.
You didn't mention the statute of limitations. That's always one of the first questions I ask the individual. I always ask, when were you hurt? In other words, when do you feel the malpractice occurred? Because if this person is on the phone with me and it happened 4 years ago, 99% of the time, that conversation dies there, right? So I always try to get a sense of when the malpractice occurred. I always ask, who was the doctor or what medical facility made the mistake? I just try to get some basics, get the person talking. But I certainly agree. I think that the best cases are those that lack real science, right? Like the best cases are those that are just, you can hear the client describe the facts and in your gut something went wrong. And don't get me wrong, like a lot of medical malpractice cases by their very nature are complicated because of the medicine, but you can just tell that shouldn't have happened. You often see situations where people are undergoing elective procedures, and our one big case where this woman goes in for an elective procedure and leaves with a brain injury. That something went wrong, right? When somebody has to go in for an unanticipated revision or second surgery, that type of thing usually jumps out at you like, well, why, right? Somebody has an adverse reaction to medication when most of the world's taking that medication without problem. Why, right? And I agree that damages are a huge consideration. I have this little rule for myself, and this is a little extreme, but I usually say if the person who was on the phone was the victim of the malpractice, it's probably not a case for me. And I've just sort of set that rule for myself because, as you were saying earlier, so many people call with important issues to their life, but not big enough to create a malpractice case out of. And I've just started to have a higher barrier of entry. And if it's not a really serious injury or damage, I have to pass on it. It's just the threshold I've set for myself. And I feel like my life is more peaceful because of it.
Yeah. And with the statute of limitations in New York State, it's 2.5 years from the date of the malpractice. There are ways to extend it, but it's rarely ever extended. But if a doctor leaves something behind, leaves a foreign object behind, then it's from the date that the patient discovers that the foreign object is left behind,
or should have discovered it,
right?
But,
And that's about the only way that I've really actually seen it extended. There's
you
also
can get a tolling for
continuous
failure to diagnose.
treatment. Yeah, with a failure to diagnose, you can, or if you're still under that same doctor's care, and if the doctor tries to hide their malpractice more or less, or tries to keep on treating you for the original issue, it can be extended. But I would say, like, a general rule of thumb is don't try to extend it. The general rule of thumb is
never bank on the tolling working for your facts.
Don't count on that, because it usually works against the patient with the tolling of the statute of limitations. So just figure it's 2.5 years to be on the safe side.
One thing that I don't think many people appreciate is that lawyers like us, we have to be selective with medical malpractice cases for a variety of reasons. The expense, the time-consuming nature, the complexity, the vigor in which these cases are defended. But another reason is the law imposes a filter. And what people don't realize is that as personal injury lawyers, we are obligated to have medical malpractice cases vetted by physicians before we can initiate litigation. And so we have to certify that a case has been evaluated and that there's, reasonable belief that a malpractice occurred, something to that effect. And we have to certify our summons and complaint when we file it. Now, that is unlike any other type of case, right? If I have a fall down case or a car accident case, I don't need to certify it. I don't need to get it vetted by an expert first. I can just assess those facts, and I'm a reasonably prudent person. So if I think that something's awry, I can sue it. But we can't even put our names on a case or start a case unless it's been certified. And what that means is, just to find out if we have a medical malpractice case, our law firm has to spend money, right? And to get a case reviewed these days is at least $1,000, right?
Yeah, at least, and
then it goes up. And so, oftentimes I think clients are maybe taken aback or insulted by our decision to decline. And I often tell people, it's not that I am making an opinion about the quality of the care or your suffering or anything of that nature. It's more that the office has standards, the law has standards, and we have to pick and choose our battles. And with medical malpractice cases in particular, we have to choose the good fights, the worthy fights, because they take a long time. And especially now with the phenomenon that you and I were discussing earlier, where you may see Dr. Smith in the emergency room, but Dr. Smith isn't actually an employee of the hospital. Now you have to sue the hospital and Dr. Smith and Dr. Smith's actual employer. You now have 3 defendants, right? You have 3 lawyers picking at your client. That's 3 bills of particulars, 3 rounds of discovery, 3 people asking deposition questions. And the cases they take a lot of time. And if I'm going to live with a case for 3 or 4 years, I better feel good about that case.
Yeah, definitely. Yeah. So as you can tell, medical malpractice cases are really rather complex. But if you feel like you have a case and you want to talk to us about it, feel free to reach out.
Yeah, and oftentimes people call, and I think that they are uncertain of whether their facts will result in a case, and sometimes we're not sure either. I always tell people, I'm not a doctor, I'm just a trial lawyer, but it's our instincts, it's our goodwill, and if you call and we think you have something, we'll be glad to help you, and who knows, maybe you'll end up having a case, and the right result, the just result, will come of it.
What is the standard of care in medical malpractice cases?
Well, I think the law says that the standard of care is what is required of a reasonably prudent doctor. Medical malpractice is medical negligence. In order to prevail in a medical malpractice case, a injured plaintiff must show that his or her doctor or medical provider deviated from good and accepted standards of care within the community where the care is being delivered. That means that you would have to show that a reasonably prudent doctor would not do what your doctor did under the same circumstances, or alternatively, you would show that a reasonably prudent doctor would do something different under the same circumstances. You typically establish this standard of care by hiring a doctor, another physician who will come in and critique the quality of care that you received. Derek, how much is a medical malpractice case worth?
Well, there's no easy answer to that. You can't just, use some magic formula to figure it out. But the factors that go into it, I'll start with the simpler ones. Those are the economic factors. So if there's lost wages, you can figure out how long the person was out of work because of the injury, and figure out what their weekly or annual salary is, and that's their lost earnings. If there's medical bills, then you would add on the medical bills. There's other economics like loss of benefits, loss of vacation time, things of that nature. And then it goes to the real meat of the case. I would say it's the pain and suffering, and those numbers can vary widely. If there's permanency, that's a big driving factor in terms of value. So if someone has an injury that's going to last the rest of their life, that's a lot of years. Whereas if someone has an injury, even if it's severe, if it only lasts 6 months and then they heal, still has value, of course, but not like a permanent injury. And I think the value is sometimes driven by the defendant's conduct as well. So if the doctor makes a good presentation and seems to have kind of just made a mistake, more or less, the case still has value, but not as much as if what the doctor did was more egregious. That can drive the value because jurors will get, upset and angry with the doctor, and could come back with a higher figure. And I also look at the impact on a person's life. So does it affect their day-to-day activities, meaning everything that they do, or does it only affect their ability to do more strenuous physical activities? So, for example, before, if they could, lift 80 pounds, now they can only lift 65 pounds. They're still fairly functional. Whereas, if they have difficulty doing basic things like grocery shopping and cleaning their home and carrying a laundry basket, things like that, the value then swings higher. So, again, there's no magic formula, but you put all these factors together, sometimes look at similar cases and see where the numbers fall, and then compare your case to a similar case. Of course, always try to get more than the last case, though.
Derek,
Yeah.
Do you hike?
Sometimes.
I've got adult ADD. I can't hike. I get like
Yeah.
30 minutes into the hike, and I'm like, what are we doing in here?
Yeah, I mean, I can't go too far on a hike, but yeah, I'll go.
If I'm hiking, I want it to be a challenge. I want to be going uphill, rocks. I mean, bring some rope. Let's climb something. I don't want to do some walk out in the woods.
Yeah. What's your favorite place to go hiking? Do you have a favorite?
Well, I don't really do too much hiking. But to give you an example, that little spot down in Black Creek with the bridge and the creek. And then it's got a very uphill part with stone, even though it's kind of like a set of stairs. I like that. I go to that place out on 28 behind Bistro to Go.
Yeah, Ontario Lake?
Yeah. Okay, quick story about that. So went hiking once with my buddy Jim and my 2 kids. They were both very little. We thought that the hike went around the lake.
Oh, no, it's a dead end.
Well, we got about halfway and realized this lake is really big. So now we're on the other side of the lake. We've been out there for a long time as it is. My daughter, God bless her soul, she made it halfway, but she had nothing left in the tank. So I got my son on my back. I've got to carry my daughter like a fireman out. So between the two of them, I'm carrying 100 pounds. And, Jim is not used to carrying kids, and my kids aren't going to let him touch them. So I had to carry these kids. I thought I was going to have a heart attack out there. I thought I was going to die. And I was like, well, I'm never bringing my kids hiking again. That was like the end of my hiking career. That was only like a year ago or so. But it was kind of funny. The fact that we made it out alive was cool.
I went once with my kids to someplace in the Adirondacks near Loon Lake, and we were at some bar there. It was my wife and her friend and her kid. So there's like 6 of us, and this guy tells us there's this beaver dam to go check out on this trail. So we're like, okay. So we started walking along, and apparently the dam was right at the beginning, but we walked over top of the dam and didn't realize it because it just looked like a trail. So we kept on walking in,
my God.
and then we more or less, like we had a general idea of where we more or less got lost in there. And my son refused to walk out. He was done. He must have been like 3 or 4 years old. He was shot. And I think I was wearing flip flops because the beaver dam wasn't very far in, and it's like which I would never wear flip flops to go hiking, but this was just like, it's a little short walk in the woods. I got flip flops on. I don't care. And I carried my son out with flip flops, and it was like my knee started to hurt. It was just an awful experience, and it was not a fun.
I got
fun
lost
time.
in the woods once on a hike.
Yeah.
What happened was we went hiking way up in like Saratoga County. My uncle brought us out. My dad was pissed. He didn't want to go hiking. So my dad, acting like a child, stays at the car, and we go in. And I can sense that we've been in the woods for a long time, and my dad has zero patience, and basically there's nothing to do. He stayed at the car in the woods. So I tried to like run back after we agreed to start heading back, and I just ran too fast and got off of the trail. I was lost. I was scared, but I knew if I followed the water, it would bring me back basically because we followed this creek. So I had a momentary scare, but I made it back, and my dad was furious that we were out in the woods for that long.
So that's a wrap on episode number 4. Thanks for watching and listening. And if you like us, then click like below. You can also click subscribe or click whatever else you can click down there. I'm not sure if there's any other options, but if you see it down there, click on it.
I hope you learned a little something about medical malpractice and the various complexities associated with these cases, but they're important, and we do handle them at Basch and Keegan. If we can help you, give us a shout. Otherwise, thanks for watching our 4th episode of Upstate and Litigate.
See you next time.